Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
In California.
Let me just make sure that it is, because we've had problems where it hasn't. Okay, perfect. Hello and welcome to SCOTUScast. I'm your host, Justin Drower, on behalf of the Faculty Division of the Federalist Society. We're here today to discuss Lac du Flambeau Band of Lake Superior Chippewa Indians v. Coughlin, which was argued before the court on April 24th. It's my honor to introduce our guest today, Tom Gede. He's counsel at Morgan Lewis and assists the Indian law practice and previously taught as an adjunct professor of federal Indian and gaming law at the University of the Pacific McGeorge School of Law. He is a member and advisor to the Restatement of American Indian Law at the American Law Institute. He was also appointed by then Minority Leader John Boehner as a member of the 9-member federal commission called the Indian Law and Order Commission that reviewed public safety in Indian country and reported to the President and Congress. And we're very happy to have him on SCOTUScast today. So Tom, thank you for coming to talk about the case.
Well, thank you. And while petitioners face a continuing uphill struggle to convince the Supreme Court to read tribal governments out of a provision of the Bankruptcy Code that abrogates the sovereign immunity of governmental units. At oral argument on April 24th, the court examined the Bankruptcy Code's definition of a governmental unit, and that definition lists multiple entities, such as the federal and state governments, but also includes a catch-all phrase, quote, or other foreign or domestic government, close quote. Petitioners argued that this definition, notwithstanding the catch-all phrase, effectively excludes Indian tribes, because Congress did not list Indian tribes separately. So argued counsel for petitioners, Lac du Flambeau Band of Lake Superior Chippewa Indians and the tribal business entities. But much of the questioning and responses revolved around whether failure to include the tribes in the listing served to exclude them, including from the catch-all phrase that seems to reach all governments, foreign or domestic. Counsel for petitioners emphasized the need for a clear statement to abrogate the sovereign immunity of tribes and relied in part on the argument that Congress expressly did that in every other statute abrogating tribal sovereign immunity. When Chief Justice Roberts posed a hypothetical to Pratik Shah, counsel for petitioners, asking, what if the code just said every government? Mr. Shah conceded that would be a harder case, but he said he wouldn't give it up because Congress has to be specific. Working through this response, Justice Barrett finally asked, it sounds to me like you're carving out an extra special super clear rule for Indian tribes. She suggested that the catch-all phrase sounded like an attempt to cover the waterfront, a phrase that was repeated throughout the back and forth between the justices and counsel. Perhaps the strongest argument offered by Mr. Shah was that Congress lists in the definition of governmental units a number of governments, including the federal government, states, and foreign governments, but not tribal governments. And then it used the catch-all phrase. Why wouldn't it have listed tribal governments in the listing before the catch-all phrase unless it meant to exclude tribes? In trying to explain why Congress may have intentionally omitted tribes, Justice Kagan asked, and I think that is the difficulty for you, is it? Aren't you really making it into a magic words requirement? Mr. Shah fell back on the argument that the pre-1978 code, the code before this particular formulation was adopted, treated tribes differently with respect to preferential treatments, like tax claims. And this current code was meant to continue the status quo. This did not seem to convince Justice Kagan, who said, if Congress really meant to exclude Indian tribes, you wouldn't have said, here are all the governments, da-da-da-da-da, and everything else we can think of. Similarly, Justice Sotomayor expressed what sounded like doubts that the omission of a specific reference to tribes in the text meant that Congress was excluding them. She suggested Congress is saying, okay, everyone, foreign or domestic, is going to be included, is going to have their sovereignty waived. and that this meant these governments are going to get certain benefits, but also be subject to certain obligations, like not to violate the automatic stay. Mr. Shaw argued tribes honor the automatic stay, but their immunity was not abrogated. The newest justice, Justice Jackson, also expressed doubts, suggesting petitioners are asking for a special separate rule that preserves the sovereign immunity of tribes in a circumstance in which Congress has clearly indicated it wants to abrogate the sovereign immunity of governments. The subsequent arguments of Gregory Rappaway for the respondent and Austin Rayner, assistant to the Solicitor General, pointed to the 1978 definition as broader than under prior law, so they posit it as a new formulation, a reset, not a move to keep the status quo with minor adjustments. As justices previously had asked how the terms foreign and domestic play out, Mr. Rappaway brought in the code's statutory definition of the word or as not exclusive, so that when Congress says or in this catch-all phrase, it doesn't mean one or the other but not both, it means either or both. And that would cover entities that may have characteristics of both a foreign and a domestic government. Mr. Rayner emphasized that there is no alternative plausible reading of the definition that somehow sows ambiguity. He noted that other statutes that specifically mention Indian tribes were statutes specifically directed at Indian tribes or involved them in an obvious way. Whereas here, the specific listing of entities focused on those thought likely to be implicated in a bankruptcy proceeding. And in 1978, tribes did not have the economic boom that came later. This may explain why tribes were not listed. But as Mr. Rayner explained, when Congress added the catch-all phrase, it was saying we are applying the abrogation of sovereign immunity to the broad category of governments. It seems the court is genuinely troubled by Congress's odd addition of a list enumerating various governments in its definition, then adding a catch-all phrase that appears to include all governments. But whether that disquietude means the court is ready to exclude one government from the catch-all phrase, presumably directed at all governments, seems pretty unlikely. After all, this is about governmental immunity. And while liberal-leaning justices tend to support tribal sovereignty, they typically show disfavor of governmental immunity from suit. More likely, the court will see the catch-all phrase as covering the waterfront, and that includes tribal governments.
All right, thank you for breaking down the case and getting a little bit into predictions there. So what would be the, I guess, implications of this decision going forward, depending on how it falls out? Like what would be the, I guess, the biggest impacts of this case?
It doesn't seem to me to be as destructive to tribal sovereign immunity as some would claim. Clearly, it would abrogate tribal sovereign immunity, and that is viewed as an injury by tribal governments. But any government that has its sovereign immunity abrogated by Congress is going to feel that injury. They're going to be subject to damages. But it's in Congress's power to exclude tribes, and Congress can do it with clear words. So it's not the end of the world, and it's not the end of the legislation. The Bankruptcy Code can always be amended. Of course, it's easy to pass a law and hard to change it. But I don't think this is one of those core tribal sovereignty issues. It seems like a fairly narrow issue and a fairly simple case. But I'm afraid the tribes are not going to get a majority of justices on it. And that includes the conservative justices who have voted against tribes and tribal sovereignty in the past, and the more liberal-leaning justices that are generally antithetical to governmental immunity from lawsuits. So this is sort of a double whammy. Can't predict the number, but I just don't see the tribes getting majority in this. It was asked by Justice Gorsuch that the tribal amicus brief came in, led by the Navajo Nation. It didn't really have a lot of other tribes except the Congress of American Indians. The National Congress of American Indians was a party, and they often represent multiple tribes. And what tribe wouldn't jump in on this and say, oh yeah, we don't want sovereign immunity abrogated and subject us to damage lawsuits. But I think the criminal law cases out of Oklahoma and the impact of the Oklahoma case really is more central to some of the big battles about travel sovereignty.
All right. So I guess closing us out, is there anything else that you'd like to mention about this case, or do you think we've gotten a good overview of it? It seems like we have a pretty good grasp of it.
Yeah, I mean, this is a quibble about words and whether excluding means including and including means excluding
Right.
The words, and is it really ambiguous or is it clear? The textualists are going to look at the text, and it is odd that Congress said, okay, here's some governments, and any other government, and I think that's what Justice Roberts was testing when he said, well, what if it said every government? Well, that would be a hard case. And they sort of pressed counsel for the tribe on how he wouldn't give it up. And then finally, he did say, I guess I would give it up, every government. But Congress doesn't always speak in such crisp, clear, grammatical terms. And so the job of lawyers and the job of justices is to sort that out.
Well, I think that's well said and a good summary of the case. So thank you very much, Tom, for joining us again to break down another Indian law case.
You betcha. Anytime. Thank you.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.